All right, so we're going to go on the record. Let me know when you're ready, Diana.
Just 1 second.
Okay. Yeah.
I was gonna use sound test, but if you want to wait for after that hearing.
Let's go ahead and do it. Just what you can.
After, on the same day? Okay.
Sure.
What was it?
You know what I mean?
All right. All right, everyone, please make sure your phones are silent or on off.
Right there.
We're good, man.
All right, court is calling 2022 CR 9807, State of Texas versus Vernon King Dixon. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Daniel Escobar for the state.
Adam LaHood for the defendant.
George Schaefer, Your Honor.
Yes. And you're Mr. King? Mr. Dixon, I'm sorry. Thank you. All right, so outside the presence of the jury, we're going to have a hearing, Mr. Dixon, with regards to a statement that you're alleged to have been given to see whether or not it's admissible. Do you understand?
This is the state.
Like a couple weeks after the rep, they play that same thing too. Yeah. So we're having a hearing. It's a case called Jackson, but we have it outside the presence of the jury. So the jury doesn't hear any of this, and the judge gets to decide outside the presence whether or not it's admissible or inadmissible. Yeah.
All right. So state, are you prepared?
Yes, Your Honor.
All right, state, call your witness.
The state calls Detective Juan Espinoza.
Well, if you'll have a seat, if you could raise your hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Excuse me.
Oh,
My name's
go ahead.
Detective Juan Espinosa.
All right, state.
Yes, Your Honor. I don't, are the speakers working? Or the?
Hello?
Okay,
Yeah, they're working.
okay. Detective Espinoza, who do you work for?
San Antonio Police Department.
And how long have you worked there?
I've been on the department for 17 years.
And what are your current duties as a SAPD officer?
I'm currently a detective in the homicide unit.
And why you're here today is that a state of Texas versus Vernon Dixon. Did you have an opportunity to interview Vernon Dixon?
I did.
And do you recall what date that was?
Back in September of 2022.
And where did you interview Vernon Dixon at?
Bexar County Jail.
And was he in custody at the time?
Yes, he was.
And before you interviewed him, did you read him his rights?
Yes,
Did you inform him that he had a right to an attorney?
I did.
That he had a right to remain silent?
Yes,
And that anything he said could be used against him?
correct.
And that he has a right to an attorney to be present prior and during any questioning?
Correct.
And that he has a right to an attorney to be appointed and advise him prior to and during any questioning?
Correct.
And he has a right to terminate the interview at any time?
Correct.
And at the time that you did interview the defendant in this case, Vernon Dixon, do you know if he had an attorney appointed to him?
I did not.
And did he inform you whether he had an attorney or not?
He mentioned if he needed an attorney.
And was that on the video that you reviewed for this
Yes.
case? And did he waive all those rights and decide to agree to an interview with you?
Yes.
And did he ever mention that he would like to talk to you?
Yes.
And so after these rights were read to him and he was informed of them, did he proceed voluntarily with the interview?
He did.
And Your Honor, at this time, would you like me to enter the video at the time?
Yes.
Let me just. Oops. Detective, you can look at that video and tell, I'm sorry, that disc, and tell me, is that, a disc that you've reviewed for this case?
It is.
And what is that, a video or a disc of?
It's an interview of Vernon Dixon.
And is it a fair and accurate copy of that, interview?
It is.
And is there a portion of this that has been redacted?
There is.
And it's actually, the video is still running, but it's been muted, is that right?
That's correct.
And that's an indication of the defendant stating that he was an ex-Crip member,
Correct.
and that's a gang,
Correct.
but that has been muted out.
Correct.
Okay, but other than that, everything is fair and accurate, copy of the original interview.
It is.
And for these proceedings, Your Honor, the state would enter, well, I'm sorry, Judge, I didn't get it
That's-
marked.
That's okay.
I don't like putting stickers on here, Judge. Would you be okay if I wrote it on there?
And Judge, the defense isn't objecting. From personal experience, I've seen it where if there's a sticker,
Yeah.
it will break in catastrophic fashion a reader. There's not much space that's in there.
All right, if you all have the sleeve and you can mark the sleeve.
Yeah.
Okay. And Judge, I know that state exhibit, I think we're on number 39. Or number 40, actually, because 39 was going to be a stipulation.
Yes,
So would you like me to mark it as state exhibit number 40?
that's fine.
What's 39 gonna be?
39 is a stipulation.
Stipulation.
Actually, I have it. Yeah, we have 38 is photos of the bullets.
Right.
Yeah, so yeah, we're good.
39, yeah.
The 39 is stipulations.
Oh, yeah. And so, Judge, for the record, the state is asking to enter state exhibit number 40 for these proceedings.
All right,
No objections, Your Honor.
all right, then state exhibit number 40 is admitted for purposes of this proceeding.
And Your Honor, at this time, I don't know if the court has had a chance to review it, or would you like me to go ahead and play
The court has reviewed the entirety of the DVD. Both the state and the defense tendered the DVD to the court to review during the break. And I have had a chance to review the entirety of the video, not the redacted video. So there's no need to play it.
Okay, Judge, thank you. And Judge, at this time, the state would pass the witness for this motion.
All right, and just for purposes of the record, defense, are you stipulating that state's exhibit number 40 is authentic?
Yes, Your Honor. We're stipulating as to the authenticity, not to the admissibility at this time.
All right. Do you have any questions?
Just a few. Detective Espinoza, were you the person that conducted the interview that we saw in the video?
I am.
All right, and you were, did you conduct any other interviews other than that interview with Vernon Dixon that day?
No.
Okay. No further questions for purposes of this hearing, Your Honor.
All right, thank you. You may step down. The rule has been invoked. You are not allowed to discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and the defense. All right. And if you'll just remain in the courtroom. All right, the court will hear argument.
Yes, Your Honor. I think it's our motion, so we can proceed. I think we go first on it. So, Your Honor, I know the court's reviewed it. Approximately around the 4-minute mark, I believe it is on the video, but certainly then first 5 or 6 minutes. The Detective Espinoza, he asked Vernon, do you have an attorney, or admonishes him. The client at that time, Mr. Dixon, says, I have a lawyer and everything else. Our contention is this. I believe the detective was put on notice that there was a defense counsel appointed, that there was an attorney present. There certainly wasn't a significant lapse in time since Mr. Dixon was provided with counsel. We think that any questioning, any statement that may have been elicited from the defendant should have been done in presence of counsel, or at the very least, interview should have been stopped at that point until defense attorney, in that case myself, could have been notified and given the opportunity to be there. That didn't happen. And what happened after that, obviously, was a statement by Mr. Dixon to the detective. Our contention is that anything he said after the detective, Mr. Espinoza, was notified that there was a defense attorney on the case should be held inadmissible. In the alternative, if the court deems that it was a proper admonishment and for purposes of this hearing under Jackson v. Dino or Dino v. Jackson, that the statement was properly admitted, we do have an objection as to two things. One, I believe, has already been redacted. That was a mention of prior gang activity, and the defense is satisfied that any mention of it is redacted in the form of the audio being muted. It's just about 10 seconds or so. And so we don't have any questions about that. However, what we do have issue with is there goes into statements about Mr. Dixon being caught in Kansas, obviously several states away after the fact. The defense would object to any statement or any reference to that being brought in, either through his own statement or being elicited by the state's office as form of testimony. And the reason why, Judge, I think it goes back to a 403 argument. I understand, I anticipate what the state argument is going to be. However, I believe that it creates an impermissible bias in the minds of the jury, saying this is somebody who ran from an offense, and it just, I believe it poisons the well. Judge, and I don't think it's proper to go into the fact that Vernon was arrested, whether he was arrested a mile away, a foot away, or 10,000 miles away. I'm not sure it's necessarily relevant to the merits of the case, Judge. He was in custody. Obviously, he's here standing trial, and I think any mention of the fact that he was arrested out of state again, puts into the mind of the jury that this was somebody that was running, that has something to hide, and therefore under Rule 403 would be more prejudicial than probative. And for that reason, Your Honor, respectfully, we would ask that it be admitted. In just 1 second.
All right. And so just so everyone can know, I believe his mother is in the courtroom. Yes. So I don't know if the state of the defense is going to have objections to her being in the courtroom and release her from the rule.
Judge, I've asked Adam to put into the record when he was appointed prior to the interview. I want that in the record.
Yes.
And for the purposes of Miss Pearl being here, Judge, the defense is not opposed to her being here. I certainly respect the rule if the state wishes her to step out.
Your Honor,
We may call her as punishment, so you know.
you're going to call.
If we get to punishment, I'm just giving you fair warning.
We'd be opposed at this particular point then for her to be present, then if she possibly might be called during punishment phase, Your Honor.
All right, Ms. Barnes, I'm sorry, but you're not going to be allowed in the courtroom because the rule has been invoked and they may be calling you later. Sorry for moving throughout the record, Dinah.
And Your Honor, sorry, on the record, I see that Cherie Lewis was with Pearl Barnes, and she's also a subpoenaed witness. So I think since the rule's been invoked, we would ask that she be outside the courtroom. It looks like she has been moved outside the courtroom, Your Honor.
All right.
Yeah.
All right, you may continue your argument. Your co-counsel said he wanted to put in the record when you were appointed.
Yes, Your Honor. Based on my records, I was appointed to represent Mr. Dixon, Vernon Dixon, on August 15th, 2022, which was anterior to the date of this interview. And I believe that's even mentioned on the tape that he had an attorney. So, Judge, for all the reasons stated, again, we would object to any admissibility of the statement. And if the statement does come in, certainly as to the part which has been redacted about any former gang affiliation, but also to any reference of Mr. Dixon being caught outside the state of Texas, due to the fact that we believe it is more prejudicial than probative. And for those reasons, Your Honor, we'll pass it off to the state.
All right, and with regards to the redactions that have been made, then the court, since the defense is in agreement to the redactions of gang affiliation, there's no need for the court to make a ruling on that because it's been redacted. Correct,
Your Honor. At this point, it would just be admissibility of the statement itself. And then if it is admitted, then we would move on to any mention, which require a little bit of further redactions as to any mention of Mr. Dixon being caught out of the state of Texas.
All right, thank you. Oh, and you all can remain seated when you do your argument. All right, Mr. Garahan.
Yes, Your Honor. In reference to the admissibility of the defendant's statement in this case, the state has proven with Detective Espinosa's testimony that the statement was given freely and voluntarily, and also that he waived his rights to have his attorney present. In fact, if you listen to that video, which I know this court has, he actually states that he wants to talk to them, and then his rights are read, and then he continues to speak with the detective assigned to this case. Also, throughout his interview, at least 2 other times that I recall, he does state that he's been wanting to talk to the detective about this case, and mentions of the reasons why he wants to talk to him. So, into the question of the admissibility of the statement, the state's position is that it is admissible because it is a freely and voluntarily waived his rights, the defendant did, and proceeded with the interview. To go to the other portions of defense counsel's, I guess, motion, of course, we've already agreed to the gang affiliation to be redacted, and it has been redacted. In mention of the defendant leaving the state to go to Kansas and was arrested in Kansas and brought back to Texas, the state's position is that that's just evidence of guilt. It's more probative rather than prejudicial, because it's probative, outweighs its prejudicialness, because the fact is, just like fleeing a scene, that can be used evidence of guilt against the accused in a case. This is where he's fleeing the scene, but not only flees the scene the day of, but then actually flees the city, well, actually the state of Texas. And that's indicated in this interview. If you look at its entirety, he mentions Kansas, and he says that he went to Kansas to get away from this area because he felt that to prove his innocence at some point. So the state's position is that the probative value of the defendant leaving the state of Texas to go to Kansas is more probative. And that's how the state's argument will rest, Your Honor.
All right, and defense, it's your motion, so you have final argument.
Your Honor, again, we would just urge, just re-urge, and I think we already said it, but I believe the detective was aware that he had counsel present. And we believe that the statement was improperly taken with an attorney appointed, or certainly representation by counsel, and the person being in custody. I believe that the interview should have stopped at that point, and defense counsel should have been notified.
All right, and defense, of course, the court does have the same concerns that you have. However, I'm just bound by what the law says. So with that being stated, your objection to State's Exhibit number 40 will be overruled. With regards to mentioning of your client being found in Kansas or leaving to go to Kansas, the court has done a balancing test. The court is going to find that it's more probative than prejudicial. So with that being said, State's Exhibit number 40, your objections to that will be overruled.
Yes, sir. Yeah, we respect the court's ruling. We just ask that you note our objection for the record.
Yes, thank you. All right, so what we will do is, deputies, if you can check to see if all the jurors are here. They're here? All right. Just one moment. Let me fill up my water. And then if you have your, is this your next witness?
Yes, it is.
If you have him take the witness stand. Yeah, you can line them up.
Just trying to help. I figured as old as you're getting.
All that staying out.
Oh, everyone, please be seated. Hey, okay. All
We
righty.
just have 1 second
Yes,
before we.
sure.
I just asked.
And defense, if you all want to check with the
What are we doing?
evidence?
Oh, that's just, that's fine. We're just trying to.
And I will give this to you right now.
Again, just for logistic purposes, and any of this, but we burned it to our
That's fine.
laptop. Okay. Just forget everything that we did last week.
No, no, we're good.
You know what? I already have it. I mean, is it? Is it printing out? Did you print it?
Yeah, it's. Yeah.
State, are you all ready?
Just a brief second, sorry,
Okay.
guys. Left the copies of this report upstairs.
Okay.
So.
And defense, do you have a copy of that report?
Yeah.
I was actually putting it out, one of them out.
It says prosecution guys,
Yes,
when they wrote.
yes, and then there's one additional one from the 28th.
I have
You
that,
should
it's
have
supplement, yeah,
Yeah,
it's all
okay,
there.
okay, I just want to make sure you had it.
It was a short supplement.
Yes,
Yes, no, we got it.
almost done, Judge.
Oh, no problem. That copier is printer slash copier is very slow.
Your Honor,
Yes,
I'm gonna talk to somebody real quick. It might be a potential witness.
sure,
So there is a rule. If it is, I just don't want to run afoul of anything.
sure. And Mr. Schaefer, if you need to step outside with him, you can. Is that 100 pages?
No, man. I know, it's taking a while.
What?
Here, prosecution guide supplement. The interview. Here. Both.
All right.
Yeah. Audio. The audio is. Yeah. Okay.
All right, Mr. Schaefer, could you check on Adam? Oh, no problem.
That might be a potential witness, Your Honor. So I know the rule's been invoked. We're just asking to wait outside in the hallway.
Sure. And I'll give you a sharp break from when the time the state rests if you all need that.
Of course. Thank you, Judge.
All right. Could you let Deputy Mejia know that we're ready for him to bring the jurors in?
Whoever went to the bathroom.
Okay. It happens.
Andres. His brother's Andres. Andres, oh yeah, his Andres, yeah.
Here he is.
Yes.
All rise for jury.
All right, everyone, please be seated. State, call your next witness.
Yes, Your Honor, the state calls Detective Juan Espinoza.
All right, you've previously been sworn in. If you'll state your name for the record, please.
My name's Juan Espinosa. I'm a detective.
All right, state.
Thank you, Judge. Detective Juan Espinoza, can you please introduce yourself to the jury?
My name's Detective Juan Espinosa. I am a police officer with the San Antonio Police Department. I've been there for approximately 17 years.
And I already stated you're a detective, so
Yeah.
please just tell the jury generally what your duties are as a detective for SAPD.
As a detective, I'm assigned to the homicide unit. My duties involved investigating homicides, suspicious deaths, suicides, and officer-involved shooting.
And I'm gonna go over it briefly, and if you can just explain, did you go through certain training that you had to, one, become a peace officer or a San Antonio police officer, and also any other type of training that you had to become a detective for SAPD?
So the training we had was as a peace officer training through the academy. Any other training, once we promoted to detective, was a lot of it was on-the-job training, caseload management, shadowing other detectives that have experience, and that's where our training came from.
And you previously stated you've been 17 years on the SAPD force, is that correct?
Yes,
And I'm gonna go ahead and take you back to March 31st, 2022. Do you recall that date?
I do.
And why do you recall that date?
That's the date of the homicide involving Vontae Boyce.
And you said Avante Voice, is that the name, victim or deceased in this case?
That's correct.
And did you subsequently charge somebody with his murder?
I did.
And who did you charge with that?
His name is Vernon Dixon.
And do you see that individual in the courtroom here today?
I do.
Can you please just point him out and identify an article of clothing he's wearing?
He's to my right, sitting at the defense counsel table. Blue and white pinstripe shirt and blue jeans.
Thank you. Let the record reflect that he has the detective has identified the defendant in this case. Now, let's talk about the investigation into this particular murder. What were your duties and what were you tasked with doing on this investigation?
This investigation initially began there was a shooting at the East Park Meadows. At the time, the victim was still alive, so Detective Guevara, who's assigned to the aggravated assault side of the homicide unit, went down to the scene and started the investigation there.
Yeah, now, I'm sorry to, not to cut you off, but you stated that it was an aggravated assault type case.
That's correct.
Why was it an aggravated assault case at that point?
Because at the time, the victim had not passed away.
And so in the aggravated assault case, the victim would still be alive.
That's correct.
And in particular, an aggravated assault with a deadly weapon. Is a firearm considered a deadly weapon?
It is.
And so would that also be I guess, a revolver, like pistol? Is that a deadly weapon?
Correct.
And initially, like you stated, that aggravated assault detective was assigned to it.
That's
When
correct.
were you assigned to it?
Shortly thereafter, I believe Detective Guevara made the scene. I think within minutes after arriving, he was informed that the victim had passed away. And then from there, I was notified.
And at that point, is that when, I guess, you're in the homicide division, is that when y'all take over the handling of the case?
That's correct.
And so were you assigned this case that particular day or that,
No, that day, that moment.
so March 31st, 2022?
Correct.
And then tell me, or tell the jury rather, what were your duties as in particularly to this case after you start handling it?
So my part that day, since I was right in the office, we're usually assigned another detective that works homicide as well. And Detective Platt was my, we call our wing. She made the scene and assisted Detective Guevara at the scene. And then she informed me that we would have one witness coming down to the homicide.
And so you stated another detective made the scene. Where were you at?
In the office.
The office?
Correct.
And you stated that a witness was coming down. Do you remember the name of that witness?
Esvalon Lewis, I believe.
And I see that you're looking at something. Can you please just tell me what you're looking at right now?
This is my report. It's called the prosecution guide.
And so in that guide, do you put in there names of witnesses or other type of investigative things that you've done?
That's correct.
And so you can refresh your memory with that. Well, please don't read directly from it.
Correct.
But you can refresh your memory, okay? And can you just refresh your memory on the name of the individual that came down?
Esvalon Lewis,
And
as far as
did you interview her that night or that day rather?
I did.
And was that done at the headquarters?
Correct.
And through that interview, were you able to gain some more knowledge of the actual murder and the murder scene?
Correct.
And at that point, were you developing witness, a suspect in this case?
We were.
And after that interview, were you able to interview anybody else in this case?
Not that day.
And then through your investigation, were there other witnesses that were deemed important in this
Correct.
case? And was there anybody else interviewed that day? Maybe not by you, but by any law enforcement?
There were.
And who was that?
I know there was one of the maintenance guys, personnel. I think his name was Carl.
Carl? Okay.
Another resident who had approached an officer. That's far.
Okay. And so throughout that process, you gain information, develop a suspect, and proceed with the case. Is that correct?
That's correct.
In this particular case, were you able that day or soon thereafter able to talk to the defendant that's charged in the case?
Not that day.
So back on March 31st, 2022, was the defendant in this case, was he apprehended that day?
No.
Do you know when he was apprehended and brought in for questioning?
From my recollection, he was apprehended sometime in June.
And when?
June of 2022.
June of 2022. And where was he apprehended at?
Wichita, Kansas.
Wichita, Kansas.
Right.
And how was he apprehended? Why was he apprehended in Wichita, Kansas?
He was apprehended, I believe, by the U.S. Marshals, and because he had a arrest for murder.
Was there an arrest warrant issued for him?
Correct.
Okay. And was it for this case?
That it was.
All right, I'm so sorry. Could a parties approach? All right, state you may continue.
Thank you, Judge. Then, Detective, were you able to question the defendant in this case?
I was.
And did you perform an interview?
I did.
And before you performed that interview, did you, in a sense, read his Miranda rights or his rights to the defendant, Vernon Dixon?
I did.
And subsequently, did he end up waiving those rights and decided to talk to you about this case?
He did.
And did he proceed to talk to you about this case?
He did.
And did you find this interview or what he was saying to correlate with video evidence in this case?
He did.
And did he ever state that he was at the scene?
He did.
Did he state that whether he knew or who did the shooting?
He did mention.
And did he ever tell you who he said did the shooting?
No.
And did he ever acknowledge to you what type of clothing he was wearing that day?
He did.
And this was all be contained in the video statement?
That's correct.
And Your Honor,
Yes.
may we approach or?
Yes. All right, ladies and gentlemen, we're going to take a 10-minute break. Is there something I need to take outside your presence? Remember my previous instructions. Does everyone understand?
Yes.
All right, everyone, please rise for the jurors.
Okay.
All right, everyone, please be seated. And we're going to take a short break.
Looks good.
Diana, you did put in the record about them having no objection to the witness having stated that the defendant was in Kansas. Thank you. You can tell I haven't went through your. Hey, you know what, you write beautifully.
All right, for jury.
Everybody's getting their steps in today. All right, everyone, please be seated. And state, you may continue.
Thank you, Judge. Detective Espinoza, after your investigation with the witnesses, evidence in this case, what was your determination and who to charge for this murder?
The facts led to charge Vernon Dixon with murder.
Thank you. We'll pass the witness, Your Honor.
All right, defense.
One moment, Judge. Your Honor, we have no questions for this witness.
All right, is this witness excused or subject for recall?
Excused by the state, Your Honor.
Excused by the defense, Your Honor.
All right, the rule has been invoked. What that means, you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. Do you understand?
Yes, ma'am.
All right, you may step down. All right, state, call your next witness.
Your Honor, the state would be offering state exhibit number 39 into evidence at this time.
I believe this was previously ruled on, Judge, outside the jury's presence, and we have no objections as it's being offered.
All right, then state's exhibit number 39 is admitted without objection.
And Your Honor, it's the waiver of consent to stipulation of testimony and stipulations stating that the defendant in this case, Vernon Dixon, was charged and convicted of the felony offense of possession of cocaine under 28 grams on July 20th, 1992, and cause number 1991 CR 0678 in the 187th District Court.
All right, and defense, you stipulated to state's exhibit number 39, correct?
We have, Judge. We've had a chance to review and everyone signed and we agree to stipulate.
All right, then state's exhibit number 39 is admitted.
Maybe I just publish it to the jury, Your Honor.
Yes. All right, state, call your next witness.
At this time, Your Honor, the state would rest.
All right, defense.
Your Honor, may we take up a motion outside the presence of the jury?
Yes.
Thank you.
All right. But ladies, we're off the record. Ladies and gentlemen, I'm anticipating, and both the state and the defense have told me that they expect both sides to be finished today. So even though you're doing back and forth, things are actually happening. So I'm going to have you all go to the back and I will call you back at 2:50. And remember my previous instructions. All right, everyone, please rise for the jurors.
Yes.
All right, everyone, please be seated. All right, and defense, you have motion?
Yes, Your Honor. At this time, it's my understanding the state has rested their case and the defense would respectfully move for an instruction of acquittal in this matter. To illustrate as to why we believe we are entitled to such, Judge, we would point out that there is a shocking lack of physical evidence on this case.
Oh, and you may remain seated.
Oh, if it's okay, the court, may I stay standing?
Sure.
Sorry, we've been sitting a lot today.
Okay.
Back's hurting me. Judge, there's been a lack of physical evidence on this case, and furthermore, I think a lot of confusion over testimony. And I believe the standard that we have to ask ourselves is, could any reasonable juror come to the conclusion that Mr. DIXON is guilty as to the offense of murder? And I believe that there has been insufficient evidence shown that a reasonable juror could jump to that conclusion, could reach that conclusion, Judge. Again, we've had testimony contravene per people saying that we were there. Defendant goes by the name of Juicy, said he didn't see any shooting. He's 15 feet away or so. People that hear gunshots but don't necessarily see a shooting going on. Again, a lot of assumptions, a lot of conclusions, but a serious lack of physical evidence, Judge. And we believe that all comes down to the fact that no reasonable juror could reach a verdict of guilty in this case. And respectfully, Your Honor, we would ask the court to instruct the jury to move for a verdict of acquittal in this matter.
Thank you. All right, State.
Your Honor, the state's position is we have proven every element of the crime, including count 1, count 2, and count 3 in this case, Your Honor. Eyewitness testimony, including security video footage of at least 2 different angles of the actual shooting or the scene that day, including other evidence, the raw evidence at the scene, and also the medical examiner, lab scientist testimony brings into the fact that the elements have been met, and this should be going to the jury for guilt or not guilt deliberations.
All right. Defense, is your motion. You have final argument.
No, Your Honor, we will rest on our previous argument as stated, Judge.
Judge, bottom line is real simple. You can look at the video and you can't tell who does the shooting. That's really the bottom line in terms of the facts that have to be determined by this jury.
All right, thank you. All right, defense's motion is denied. Defense, are you calling any witnesses?
Your Honor, may we confer with our client just for a few minutes?
Sure.
Actually, I'm going to step out with Mr. Schaefer and talk with somebody, and we'll be right back.
All right, of course. Then while they're doing that, Mr. Martinez, you have a motion for occupational license?
We'd ask you to get some information together about
Yes.
the household duties and essential needs that Ms. Johnson has.
And what is this date who would be on the request for an occupational license?
I will.
All right. This is information that I requested. All right, so we'll put this on the record. The court is calling 2023 CR 3852, State of Texas versus Kaylin Johnson. Can I have parties announced for the record for the state? Defense? And Ms. Johnson is by Zoom. Any
Yes, ma'am.
objections to her appear by Zoom? State? Defense? All right, so there's a request for occupational license. Defense is your motion. You may proceed.
Include all relevant information in addition, it's been checked by the staff attorney's office. Ms. Johnson is eligible for an occupational license. The state's not opposed. It's a true authority. We've
made sure that the language in the order tracks the new law. And Ms. Johnson's essential needs that she obviously needs to do grocery shopping for herself and fulfill those things. She has to give her community service hours and she has to give her needs. So her doctor is in one of the counties. Her, she's got a home in Karnes County that she needs to look after from time to time. And then her day-to-day business brings her into contact in Comal County, Kendall County, and Garrett County. She lives at on that northwest corner. So we're asking for those routes to be included in the order. And we, for the record, have included letters from her and from her doctor and her children to indicate what their essential needs are.
All right, and the court will note for the record that according to the true bill of indictment, the first DWI was in 2006, the second one is in 2007, and this one, the third one, is 2022. Ms. Johnson, can you raise your right hand for me, please? Do you solemnly, and if you could unmute?
Yes, ma'am.
Oh, gosh, we have a problem with volume. Could you speak up, please?
Yes, ma'am. Can you hear me now?
Can you click on the audio on your phone?
I'm on my laptop.
All right.
Can you hear me now?
Yes, I can. Thank you. All right, Daniel, you can never leave. You're the tech person. All right. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Kaylin Johnson.
All right, can you speak up louder, please?
Kaylin Johnson.
All right, are you able to hear that? All right, just one moment. All right, could you speak again, please?
Yes, my name is Kaylin Johnson.
All right, so the court is in receipt for an application of occupational license. And the court has received several letters. So can you tell the court what is your reason for needing an occupational license?
Yes, I'm not working anymore. I worked up until the time of the DWI on December 27th, but I'm an RN and you can't really work as an RN after a DWI. And I will be doing housework for several people that will pay me. And my mom she's 92 and she had a recent fall where she was in BAMC ICU and she recently went home. And she needs me to help take care of her as far as bathing and cleaning her house and helping with her animals. I have 150 hours of community service that I need to deal with. I've been attending my 4 meetings a week, primarily on Zoom, but fellowship is a big part of staying sober. So I would like to be able to go to AA meetings in person, live meetings. My doctor is in Seguin, and of course I have to buy groceries. And
So have you previously been doing AA meetings by Zoom?
yes, ma'am. My sponsor picks me up like once every week or two to take me, but it's become, it's hard for her to get over here and get me before getting to a meeting. So yeah, I've been doing Zoom.
Okay. All right. So I'm going to grant the motion for occupational license without objection, but I want to see how you do with the occupational license. And then later your attorney can come back with regards to doing your AA meetings in person and not by Zoom. So if you'll come back in 3 months with regards to doing the meetings in person, then the court will consider that. So you're not allowed to do the AA meetings in person. You can do that by Zoom.
Okay. So
yes, if you obtain a ride to the Zoom meetings, to the AA meetings in person, then
yes.
You have that, you can do it in person, but you can't drive there yet.
Okay, can I go to the grocery store?
Yes.
Okay. All righty, thank you.
All right, and the court is notating, normally I don't have people caring for people, but I see that your your mother is 92 and that she had a fall.
Yes,
All right, is there anything else? All right, thank you.
thank you.
All right, thank you, counsel. And I'm going to sign off this and then you can get a copy of it. All right, you can zoom out now.
Off the record, right?
Yes. All right, so Mr. Schaefer, are you all going to have any witnesses?
No, Your Honor, at this time, the defense would also rest.
All right, so let's bring in Mr. LaHood.
I just paged him.
All right. And so we'll bring the jury in so you all can rest and close in front of them. And then after that, I'm going to release them and have them come back on tomorrow at 9 a.m. for closing arguments. And I'll have everyone stay here so we can go over the jury charge.
Yes, sir.
Yes.
Speaking of which, and here he is.
Ah, hey, and we say his name 3 times, he appears.
Yeah, of course.
Yeah.
Thank you. Yeah, thank you.
You know, if you have it memorized, write down on your.
And then attorneys who are called back for the afternoon docket, after I release the jury, we're going to immediately take up your case. We're ready.
All right, for the jury.
All right, everyone, please be seated. All right, the state has rested. Defense.
Your Honor, this time the defense would rest and close.
State, do you close as well?
Yes, sir.
All right, you may be seated. Ladies and gentlemen, this is all of the testimony you're going to hear in this portion of the trial. So this is what I'm going to do. I'm going to give you your instructions, and these are your instructions. You are not allowed to start deliberating in your mind. Do not think about this case when I release you. You're not allowed to deliberate with each other. You're not allowed to watch anything about this case. If you see something or hear something about this case, completely ignore it. My rules still apply that everything that you learn about this case is to come from inside the courtroom and nowhere else. Does everyone understand?
Yes.
All right. We can go off the record. So this is the order of things. Tomorrow, we're going to start at 9 a.m. Even though I have a docket, this case will go first. What will happen is I'll read to you the jury charge. You're not going to have to memorize that because you'll be given a copy of it. Then both the state and the defense will have a chance to give their closing arguments to you. Then after they've done that and you've selected a jury foreperson, that's when you will be allowed to begin your deliberations. Does everyone understand?
Yes.
All right. So again, on Tuesdays, the parking garage will get filled. You guys now know how the parking garage fills up. So to make sure you have a space, probably if you're here by 8:15 or 8:30, you'll be able to get a space, and we'll start exactly at 9. Any questions? All right. Thank you all so much for coming. All right, everyone, please rise for the jurors. Enjoy the rest of downtown. When do you get a chance for this cool weather? All right, and state and defense, if you all would go over the exhibits with Donna and make sure she has them all, everyone else can be seated. And then if you all will make sure you look over the jury charge and see if there's any objections.
Yes, sure.
Oh, it's up here. It's right there. Yeah.
I put number 4 to them.
Why don't we do?
Yeah.
Yeah, that's fine. Are you gonna do the ones that are admitted?
All right.
Thank you, Judge.
Here's my list. So everything that's highlighted except for this, because my highlighters are on, but everything else is on there except for the 39. Different. Everything that's checked off is at the end. Sure. And Deputy Mejia, if you all want to take him back, you can. Mr. Dixon, what will end up happening
Yeah, it came in later.
is once they are ready to put things on the record tomorrow morning, we'll make sure you're here for that.
It's on there as a
All right.
photo, yeah. Yes.
Yes, if you can do.
Yep.
Oh, yeah, that's not.
But hold on. 18 was not a big.
I had that one, yes, just because of that photo. What was the photo taken at the,
You know what? I think you're right. Let me double check. It was not admitted at the time, but I think it came in later. Yeah, 18, but it came in with an ME. They couldn't get into the first one.
Right.
So we're good.
That's the picture.
We're good.
yes,
Yes. Yes. Yep. Yes. Well, there's also 23A. We have that.
and 24A.
And
24A,
yeah. 25.
25, and 25.
A.
Yes. Yes. That's.
And then I have 26,
I have it.
24.
Yeah. I'm sorry, guys. I lost.
26.
Thanks, George. I'll text you. My apologies. Yes, ma'am. That's correct. Yes, sir.
Okay. All right, thank you. And Will Brooks, you're here for a case? Hi.
Yes.
Oh, you're here for 5 cases.
It's 38.
Seems like it's more of a shit show than it.
Oh, you know what that reminds me of?
Yes,
Christmas. 5 golden rings.
Yes. 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 Yep. Yep. Yep.
It is though. And then you have the neighbor who says, I'm sorry, I only want Domino sugar. Yeah.
What about that charge? Have you gone over it?
Yeah, I'm gonna go over one last
But
time.
Will, if your next door neighbor calls you and says, do you need any vegetables? That's when you should say like, wait a minute, what's going on? Why are you just calling me, offering me stuff?
After the law has changed, I think that's the proper title.
Proper title?
Yeah,
Okay.
unfortunately, I hate it. I really like when it's all felon possession.
Yeah.
But no, because they're technically both under the same statute, 46
And I mean, it's.
C or whatever it is.
Yeah, so I mean, I'm okay if you want to keep it that. way.
It's always a pleasure talking with you, sir.
No, definitely.
You too, sir. Try to keep it professional, try to keep it cool.
That makes it a little bit nicer.
So, no need to get mean.
Oh, I'm sorry, did you want to go over it again? or do you want to-
Over which one? We'll talk to her. Yeah,
Have we approached?
Yes.
we don't need to be on the record.
All right.
I don't anticipate that offense is gonna have any suggestions, corrections, or omissions from the charge. I think it's fine as the way it's presented. I don't anticipate any offense that you really raise on this thing. But I'll read it again prior to the time tonight, and if there's something I missed, I will certainly let someone. If I find anything, I'll text y'all tonight, or email you, so we can
Okay.
maybe start trying to work on it, but I don't anticipate anything judged.
All right.
The law changed. Well, the law changed in 2021, September of 2021, so I really hate what they call it now. I think I kind of like when felon possession of a firearm, but
Yes.
the proper term is unlawfully carrying a weapon with a felon.
Oh, it does not. So you all want it changed to
Well, all it states is.
It does, because it's all, yeah, the thing is, it's all under the same statute. We get to the same result, well, honestly, it's official, so.
So here's the question.
Yeah.
Can I have that in the printer, please? Do you all want to think about that and make a decision on whether or not you want that changed?
Yeah.
Oh, that's not
I'll
possible.
read it again, and I'll double check, but I think this goes just after the law had changed from felon possession to unlawful carrying with felony conviction. But let me double, my memory's not perfect. Obviously, so let me double check in case it was 2022, but I think it changed to 2021, didn't it? Yeah, I think it did too. But I'll double check. If it is under the old statute of felon possession of a firearm, then we'll have to go back and obviously figure out. I am for what an old card and find it, but if it's under the current law, as much as I don't like the wording, I think it is the appropriate.
Okay, sure.
So,
We're gonna find that out before you leave here.
actually, I'm gonna go through, I can check. that real
Okay.
quick.
Yes,
So it'll be under chapter 46, I think.
yes. And Jason, if you could call Luis Martinez and tell him I would like to use my own order for that
Okay.
occupational license instead of his.
Here we go.
It truly is a Monday and a Friday rolled into one.
Unless you want to talk to Hank about it.
And when you get a chance,
I
could you
think
bring me
Don
the
actually
file
goes in the
on,
file.
thank you, on Kay Johnson?
Yeah, look for it. What's the guy's name? It was on your. Yeah, we would.
I'm just not-
Could be the box down.
The judge, the proper term would be unlawful possession. Yeah, it's the new law, which so means it's right to say this for.
Yeah.
Because you gotta actually reference two statutes.
Mm-hmm.
You gotta reference 4604 and 4602, and why they changed, I don't know, but.
So you don't have any objection to the charge?
No, Judge, I'll read it once more again, because
Okay.
George, I know has a copy, you can look over tonight, but I don't anticipate much.
All right. All right, thank you.
Yes, ma'am.
So I don't know.
Judge, may we be excused?
Yes,
All right, if, I think everyone has my cell phone, if something comes up, text or call, or I'll be around.
all right, thank you.
Yes, ma'am. Yeah, you have my number.
Got it.
Thanks, sir. Where's Norma at? She out the whole week?
Yeah, she's out. She has a matter to take care of.
Oh, no.
You gotta. Under your release, under the release.
Under here?
Yeah, so you don't leave it there.
Oh, yeah, thank you. One of my extra notepads. Thanks, bud.
Like he was.
You do what you can do.
And everybody, it's not going to. My wife was like, yeah, no. Where's the coyote? Does it catch him? Yeah, he's like, yeah, but not ever. Hit a fire.
So.
It's probably luxurious. A hardwood floor would be like graceful.
Actually,
You probably heard the hardwood floor, right? Solid gold. Dude, they're looking. I'm so excited. I know, I am too. I know we're not getting the results right now, but they look stout. It is. I want to watch every single one. I put them on.
I mean,
And even when we're losing, I still want to see.
permanent's not as clear cut, actually.
He out of the fire. If they're down, he might fucking get that.
If you want to do it, I want to do it.
All right, thank you.
Code actually doesn't say that parents have to join in the wait. So I don't understand why the heck we do it.
Yeah. Second, yeah, like, turn that corner. They're gonna be a fucking formal.
Yeah,
Because.
No.
Either am I.
No, it's absolutely, I mean, especially on these C and T. It's just sad, sad.
They'll see it.
No, they're reviewing it. They're gonna come in the morning.
Sure.
No problem.
You know, we
Uh-huh.
finals, and we old man ball then. Not the finals, but in the playoffs.
I've never won one.
No.
And you're gonna lose.
And you don't have that.
It's all costs.
And that's what happened.
30%.
Every like 3 minutes. Kurt. There's people who just need to bench. Johnson run. Don't give him up. And it worked. But now Curry got better. Stop working.
The judges just spoke, you know, I mean, that's.
Kevin off last night.
Right.
Oh, yeah. Number 42. I'm like, this is 42. Yeah. I think well tonight. Yeah, the games are fun. Again, because they were horrible. Yeah. You want to take a look? I saw you on TV. Check it out. Hey, God, what you doing? I just don't know how.
Crazy, huh?
I
tell
you, man, try it, do something else.
Yep. That wasn't mine.
No, it was, oh, they weren't your people. Oh, geez.
No, those were my people.
December 29th, so that's sort of the weird thing too, like, we're gonna get one more.
Then I really don't know what you.
I
think it was Adams, wasn't it?
Yeah, it was Adams.
Oh, my God. And like maybe, you know, if there was a provision, right?
Hi.
You want to throw on. Yeah, what else you put on it, like,
These are more comfortable chairs.
Can't do that too. Yeah, myself, otherwise I'll. Sounds pretty good. Yeah, that's really good. Pretty good. All right, I'm gonna approach. Okay. Yeah. Because I know that first setting, we're thinking like. Yeah. Yes.
Yeah. Why did Adam walk out?
The rest of
Rush is bringing in the morning to reason. Charge, so. Who's the defense?
I had forgotten.
Always Adam.
His daughter.
No, no.
Maybe. It's just not in the house everywhere. I've seen it.
Oh, yes, yeah. Yeah, it was in the news.
Yeah, sure. Or something. Yeah, sure. They go to video. No, they don't. How they gonna prove it? 3 or 4 people that say he did. They saw you. Let's not prove it. Yeah. That's one. Because Lance won't.
Lance has all the. And step up, man.
I'm ready.
Joe Serta, all right, what is happening with Joe Serta?
Watch the door.
All right, thank you so much.
Top row, first three, and then
All right,
2, 3, take the bottom.
Lance on Joe Serta,
Bottom
if I
row,
could have a 30-day reset for
bottom
discovery,
row.
and if there is blood draw or breath, that order that you all need signed, let's get that done between now and then. All right, we're gonna come back on December 14th. And let me see, where is? All right, December 14th. All right. Once you sign the reset form, you're excused. You're welcome. And Lance, that'll be for discovery.
Victor Garcia. Sir. Sir. Can I move Mr. Garcia to the end over here?
Did your client last?
No, it's about.
It's probably the state.
Our attorney that represents us.
Lance, thank you for filling in for us.
I don't want any trouble.
This guy's dangerous, you know? Have you seen the video? Muy peligroso.
Oh, no. Oh, no. I think Lance Aldridge has. Lance Channing.
All right, could I have a state's attorney on Carla Gonzalez, please? Dinah, we're gonna go on the record. Court is gonna call 2023 CR 8336, State of Texas versus Carla Gonzalez. Could I have state announce? All right, this hearing was scheduled at 9 a.m. It is now 3:18 p.m. And the defendant has not made an appearance in the courtroom. State? All right. Court will issue a judge's warrant and remand her without bond. If she makes an appearance, the court will reconsider. Thank you. Jessica, are you sure you're pronouncing that correctly? Just like with me with Quetzalcoatl, I think. Ah.
Yeah.
All right, Jose Amezcuz. We're gonna find out how, I'm gonna find out how to pronounce it. Amezcua? Okay, what is it? So the C-U-Z is Amezcua. Qua. Okay. Amezcua. All right, so on this case, where are we on discovery? I see it's a first setting.
I've received the police report, the lab results, the lead body camera. I have to double check if we have dash, that it is a first setting. Mr. Lalo has an immigration attorney. His name is Eric Bernal. We reached out to him before. We will forward the office to Mr. Bernal. And we're asking for a second trial set.
Okay. And states you haven't been able to tender an offer, is that correct?
We got an offer today.
All right. All right, Lance, if you could put this in December, and that will be your plea deadline date.
Thank you, Judge.
Sure. December 14th. Do you have any questions, sir? Yes. I have 3 children here. Well, that'll be something that you'll need to speak to with your immigration attorney and with your defense attorney. I don't know. Are you saying there are a CPS case, or what are you saying?
It says like maybe 20 years is okay, but it doesn't say like.
Yeah, all right, so where are your 2 children now? Who is with them? They are there. How old are they? One is going to start being treated, the other one is 15. So are they at home by themselves, not supervised? Their mother checked up on them. All right.
We do have her, I believe that's Daniela. We have her name and her number.
So if you'll check on that, because I don't know with regards to school age about an 18-year-old and a 15-year-old. I know legally an 18-year-old can supervise. But that's something you'll have to speak to your attorney about. All right, and just as a side note, where is the children's mother? See, now I have more questions. But I mean, why is she not with her children? So are you saying, and this is just making me ask more questions. So are you saying that she no longer recognized those two children as her children? Or does the person she is with does not want her to be with those two children?
No, she does acknowledges that they are hers, but they want to be with me.
Right.
Yes, the mother of my other child.
So who are the adults in this house and their relationship to the children?
The adult is Daniela.
All right, and what is her relationship to the children?
She's the mother of my youngest daughter.
All right, and is that the 15-year-old or some other child?
No, she's the youngest one. She's 6 years old.
All right, how many children do you have?
Me, 3.
All right, so what are the ages of the 3 children you have?
17, 14, and 13.
Okay, where does the 15, did he say 15 years old at one point and 18?
He's gonna turn 18.
All right, so are all 3 of them living in the house together?
Right now, yes.
All right, so Mr. Stateson, if you want to check on that with his attorney, I mean, this isn't civil court. I don't know about your 18, well, soon to be 18-year-old or your girlfriend, current wife. I don't know how that living situation is, but your attorney can check into that even though he's not your family attorney.
It's fine.
All right, thank you. Is there anything else? Thank you. All right, Stephen Anthony Estrada. Hello.
Judge.
All right, so Eddie Brovinick was listed on this. What's?
So he's the attorney record judge.
Mhm.
I thought I was coming over here to be for him.
Mhm.
But the offer doesn't match what I thought the offer was.
Mhm.
Estrada has some questions for his attorney that is not in a position to give an answer, if that makes sense. Judge.
All right.
So I-
This is what happens when people tell you to come over.
My fault, to a fault, Judge. I like to try and be helpful, but
All right, let's recall this back for tomorrow. We'll bring you back tomorrow. You're welcome. Thank you for coming over. And Lance, can you make sure there's a hold in the system for him and he's not to leave to go to some other county? Because
I know he's
said
set in Hayes.
County. So if you'll just put a hold on him to be here.
Okay.
Oh, so sorry. Oh my gosh, it just slid right off. I'm sorry. Oh my gosh, it. All right, thank you.
There's like a old staple.
And so Deputy Mejia, we're finished with Stephen Estrada. Another Spurs fan.
I represented a guy, their county deputy, who was charged with.
Mr. Raphael, what's happening with your case?
We're taking a free vote.
All right, thank you.
Judge, what if we discuss something about the motions?
Oh, let me review that. Yes. Who is that? Mhm. Okay. Could I see the file on Soto Victorina? So that the deputies can make sure that they get them back in time before the 5. We'll recall him for tomorrow. All right. Okay. Okay. All right. Could I see that file? All right. So Deputy, you can take back Juan Carlos Soto Victorino. We're gonna bring you back tomorrow.
Okay.
Luis Hernandez. Where's Luis Hernandez? Is he in custody or on bond?
Hernandez? Lewis?
I thought I was just having a conversation by myself. Thank you. I appreciate that. All right, we're gonna recall you for tomorrow. Make sure you're on time because you were late today. So that's why your attorney isn't here. Once you sign the reset form, you're excused. All right. You're welcome.
On this one, because all of these reports are confusing as all hell. I'm not adding the arrest warrant. Because it says everyone's names, whether it's like, this is the cleanest one.
And could I see the file on Alan Mayo or Mayo? And can you let me know whether or not he is on a PR bond or surety? I think it's a PR bond.
Tomorrow. I think we're good.
Thank you.
Good to you. Sure, it's been a moment.
Could I have a state's attorney on Alan Mayo or Mayo? Court is going to call 2023 CR 9481, State of Texas versus Alan Paul Mayo. Yes, for the state.
Sorry, Judge. Hank Wilkins for the state, Your Honor.
All right, this case was originally set on November 8th. The defendant was a no-show. The defense attorney informed the court that the defendant may be homeless. The court allowed the defense till today to find Mr. Mayo and have him appear in court. He has not appeared all day. State.
Your Honor, we're asking for a bond forfeiture.
All right, that will be granted and the court will note, a judge's warrant will be issued and the defendant will be remanded without bond and the court will note that this hearing was scheduled at 9 a.m. It is now 3:39 p.m. Thank you. And Kent Yates, Mr. Ocher's door.
No, that guy's pending another psychological evaluation.
Okay. All right, could I see the file on Kent Yates? Okay,
During the second or the seventh.
okay. All right. Well, let's put that a recall in December just to see where we are with the report. So what date, Lance?
Right now, the evaluation is set for November 17th.
All right, so let's put it a month out then.
December 8th.
All right, thank you. I'm so sorry. And could I see the file on Jose Cavazos? Thank you.
Oh, Rafael's plea.
Hello. Yes, I can. Oh, I'm doing fine. So what's the update on Mr. Cavazos?
Fíjate, es un segundo. Por eventos. No, not por eventos. North Padre, or Bob Hall here. Did you go down there much?
I can't remember the last time.
This was just, no, my brother has a house down there, my younger brother. So I was down there, about 3 weeks ago. God, man, it was beautiful. Oh, really? Okay, that's where Judge is from.
All right, are you available on December 18th?
Springhill.
No kidding.
Yeah, yeah.
So they're not like right on the water. You can walk down the street.
They're like, that's good enough, man. In fact, it's better.
All right, I'm gonna put it on that day.
On the
All right,
seawall.
thank you, bye-bye.
Storm stuff, you know.
You're welcome. Thank you,
My
bye-bye.
brother had one in Port Aransas, that same brother.
Lance,
Uh,
on
Hurricane
the
Howard
Vassos,
did a lot of damage to his house.
the DNA has been submitted, but they're waiting for the
And
results.
they moved down.
So you can recall
down
that for
the highway.
December 18th, and we'll see whether Bear County Lab is on
They live down there full time?
Yeah.
that.
Yes, yeah, he's retired.
That's awesome.
My younger brother retired. I'm like, man, what's wrong with me?
Watch, it's not gonna happen this time. It's for-
She rented out.
B&B.
Yeah, but it's, they can't do short-term rentals. I'm like, that's really.
She can only do what, like for a month or something?
Yeah,
Or a
I
week?
think the way it's. We only have one renter, so she could actually do it for one like weekend, as long as that's the only one that month.
Yeah.
I think what they're, because they don't know about people.
Shuffling in and out. It's a house,
Yeah, it's a house.
but it's not her primary home.
No.
Wow, that's nice.
Yeah. Well, I was thinking, like, part of the, that's probably better. Yeah, it's like easier on the house.
You don't have as much income, obviously.
Yeah. Well, maybe.
Oh, yeah. Yeah.
Danny Showalter. All right, then do you have a stamp? That's okay. Court is going to call 2023 CR 2763. State of Texas versus Danny Showalter. Could I have parties announced for the record for the state?
Hank Wilkins to the state, Your Honor.
Scott McCrum for Mr. Showalter, Your Honor, standing in for Jim Tochi.
All right, and are you Danny Showalter?
Yes, ma'am.
Do you have any objection to Mr. McCrum standing in?
No.
Counsel, have you received all the discovery and was it reviewed with Mr. Showalter?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding under the lesser included offense of terroristic threat.
Any objection?
No objection.
I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it?
Yes, sir.
And did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of terroristic threat as a Class B misdemeanor? The range of punishment for that offense is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes, sir.
If you have a plea with the state, the court doesn't have to follow that plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent?
Yes, sir.
Did you understand by entering this plea, you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe.
Mr. Showalter, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea Punishment is to be assessed at 1 day in the Bear County Jail. State is proceeding on the lesser included offense of terroristic threat. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Your Honor, with an understanding of credit for time served,
All right,
and
state,
it's satisfied.
all right, state, is that the plea?
Yes, Your Honor, that's.
All right, showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes, I did.
And did you sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense of terroristic threat as a Class B misdemeanor, how do you plead? Guilty, not guilty, or no contest?
I know.
State any evidence.
Your Honor, I offer State's Exhibit 1 and the attachments.
No objection.
All right, and state, have you spoken to the complainant?
Yes, ma'am. I spoke to him a couple times today, Judge.
All right, and are they aware of this?
Yes, Your Honor, I spoke with the planning witness about the strengths and weaknesses of the case and what I was considering, and he agreed with what we decided to the plea.
All right. You may continue to confer.
Thank you, Judge.
I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing? Right. Mr. Showalter, what's the problem? Like this?
Frankly, just being a good child. Something good. What I thought was a rock in my truck, I acted like it.
Why you speeding? I don't know why speed. Well, I mean, they're saying that you were driving fast through the neighborhood. I don't know why people do that. People always want to go 40 miles per hour in a neighborhood.
Wasn't getting fast. Somebody threw what I thought was somebody threw a rock in my truck. I got in my truck.
How old are you?
45.
Yeah, I don't know why people leave their vehicles instead of calling the police. That's never a good idea.
Yeah,
All right, anything you want to say on behalf of your client?
No, Your Honor.
All right, the court will sentence you to 1 year in the Bear County Jail, give you credit for any time served.
You said 1 year, Judge.
I'm sorry. See, I'm seeing if he's listening. He's not, he's stunned. 1 day in the Bear County Jail. Give you credit for any time served. There's to be no contact with the complainant in the case, and that is 1 Avila. And I'm assuming this is judgment satisfied?
Yes.
And the court will show that the judgment is satisfied. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. You're grown. You're gonna have to start making better decisions, and getting it out of your vehicle if there's an altercation is never really a good thing to do. Just pick up the phone, call 911, go to a different location, wait for the police to arrive. Do you understand? All right, good luck to you. Thank you, Mr. McCrum.
Yes, we must. Stand up. Right,
All right, Lance, is this the last case we have? Okay. Again, it's a Monday. People disappear. Yeah, I think this may be the last one.
Y usted está también revisado con los documentos que sean renuncias, estipulaciones y testimonios y estipulaciones. Yeah.
Did the attorney have an opportunity to go over this before?
Ustedes también tuvieron la oportunidad de trabajar en documentos antes de firmarlos. Yes.
To the best of your knowledge, is true and correct.
Y jura a su leal saber entender que son ciertos y correctos. Yes.
This is your signature.
Firma ahí. Yes. Y ahí. Yes.
From your report admonishments and your jury waivers.
Y está familiarizado con este documento que es su renuncia a un juicio conjurado y las advertencias del tribunal. Yes.
Did you and your attorney discuss your constitutional rights and did you understand them?
Y usted y su abogado hablaron de sus derechos constitucionales y los entendió. Sí. Yes.
Did your attorney advise you that by signing this document today, you're waiving your right to a jury trial and agreeing to a plea?
Y su abogado le informó que al firmar este documento usted está renunciando a su derecho a tener un juicio conjurado para poder entrar a un acuerdo declaratorio. Sí. Yes.
This is your signature on both parts here, as well as.
Y ese es su firma en ambas partes. Yes.
That's all I need. Y'all can have the signature this year.
Puede tomar asiento, baje la mano y ahorita le llamo. So now.
All right. Fernando Espinoza Rodas. And this is a plea on one case only?
Yes, sir.
All right, court is calling 2023 CR 2764B. Can I have the file stamp, please? State of Texas versus Fernando Espinoza Rodas. Could I have parties announced for the record for the state?
Rafael Leal por Fernando Roda.
And are you Fernando Espinoza Rodas?
Yes.
All right, and we have an interpreter here. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and from Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Norma Nero.
Counsel, are you able to speak Spanish fluently?
Yes, sir.
And were you able to confer with your client in the Spanish language?
Yes, sir.
And were you able to go over all of these documents with your client in Spanish?
Yes, sir.
Mr. Rodas, were all of these documents reviewed with you in Spanish?
Yes,
And did you understand all of the documents?
yes,
Counsel, have you received all the discovery in this case? And did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Rodas, did you review the document entitled True Bill of Indictment with your attorney? And did you understand it?
yes,
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Yes, sir.
All right, can we go off the record? Is this the correct code that's in the system? Because the code in the system, according to the indictment, is listed as engaging in organized crime.
And I noticed that, Judge, I mean, it sounds like the count says written in, or the indictment as it's written, at least on our end, it was as if it was an act kidnapping with 2 victims, and then it listed out co-defendants.
So we need to make sure in the system that this is listed as an aggravated kidnapping, because it's not listed as that in the system. All right.
In that case, it's gonna be taken into consideration.
All right, what I can tell you is the aggravated kidnapping case is 2023 CR 2763C. And what you are pleading to is 2764B. So I don't know if you,
In the indictment with that number.
all right. So this needs to say C instead of B. So I don't know if you all want to change the cause number on this, but if you do that, then the indictment listed is not going to be the indictment that's in the other cause number. So state,
Judge, if you give us a moment, I think we can
Sure.
figure this out.
okay. Oh, if y'all want to have a seat.
Yeah.
Mr. Smith, I haven't heard from.
Sure. All right, where's Mr. Smith? All right, Mr. Smith, if you'll come down, please. And could I see the Hello, Mr. Smith. All right, so, Mr. Smith, your attorney isn't here today. So we'll recall you for tomorrow. And if your attorney doesn't show tomorrow, then we may end up doing something else, all right? So we can recall him for tomorrow. All right, we'll bring you back tomorrow. All right, you're welcome.
Oh, yeah, I think that's the issue. I'll switch it.
Hurt yourself. You can take one night.
Here you go. See if you should the rest of it more change.
Like everything else? No, I mean, we can just, you know.
Yes.
Otra vez vamos a sacar las marcas.
Gracias de migración. Levante su mano derecha y mantenga levantada. Ya se ha corregido el número de causas. Ustedes la persona espinosa rodas en esa causa. Yes. Y una vez que se ha corregido el número de casos, usted tuvo la oportunidad
de hablar de este documento con su abogado y entendido. Yes.
We're still entering into the plea, and that's what we want to do today.
Y usted está entrando en un acuerdo declaratorio con el Estado de Texas y esto es lo que usted quiso hacer en este número de causa.
Sí.
Yes.
What's the case number on your convention?
Es-
That reduced the trunk call to
Ese número de causa en este documento no ha cambiado. Nos puede decir si todo es cierto y correcto a estudiar, saber entender.
Sí.
Yes. Es todo lo que necesito. Un par de minutos y lo llaman.
Oh. All right, court is going to call 2023 CR 2763C, State of Texas versus Fernando Espinoza Rodez. Oh, can I have the stamp, please? Hey, no problem. Can I have parties announced for the record for the state?
Daniel S. Barr from the state of Texas.
Rafael Leal, por Fernando Espinosa Rodríguez.
And are you Fernando Espinoza Rodez?
Yes.
All right, if I could have the interpreter, if you could raise your hand. Do you solemnly swear or faithfully affirm you will translate from English into Spanish and Spanish into English? So help you God?
I do, Your Honor.
All right, thank you. You may lower your hand if you'll state your name for the record.
Norma Nilo.
All right, defense. Do you speak Spanish fluently?
Yes, sir.
All right, and all of these documents are in English. Did you review those documents with your client in Spanish?
Yes, sir.
And Mr. Fernando Espinoza Rodez, were all of these documents explained to you in the Spanish language?
Yes.
And were you able to communicate with your attorney in Spanish?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Rodez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Espinoza Rodez, did you review the document entitled Court Admonishment and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with aggravated kidnapping? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow that plea agreement. If for any reason the court does not follow your plea agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, I believe so.
Mr. Espinoza Rodez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promise you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes,
Are you a U.S. citizen?
no,
Counsel, did you advise him of the consequences of pleading no contest or guilty and the application of federal immigration law?
Yes, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes, Your Honor.
And do you believe your client understands the immigration consequences of entering a plea in this case?
Yes, Your Honor.
Mr. Espinoza Rodez, did your attorney advise you of the consequences of entering a plea of no contest or guilty and the application of federal immigration law as it relates to this charge?
yes,
Did his advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
yes,
Do you understand the immigration consequences of entering a plea of no contest or guilty to the charge of aggravated kidnapping in this case?
yes,
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
yes,
According to the plea bargain agreement, punishment is to be assessed at 13 years in the prison. There are no applications. The state will take in consideration 2023 CR 2764B. Do you understand, if the court finds from reviewing any exhibits that are admitted that this was aggravated, that the court will apply an affirmative finding of deadly weapon?
yes,
Did you understand that to be the entirety of your plea bargain agreement?
yes,
State,
Yes.
is that the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes,
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense of aggravated kidnapping, how do you plea? Guilty, not guilty, or no contest?
no, no contest to the charges.
State any evidence?
State offers States Exhibit 1 and all attachments.
No, Your Honor.
Mr. Espinoza Rodez, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes,
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
yes,
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same.
Yeah.
Yes.
That's juicy. And then it done.
All right, if we could go off the record for a moment. Can you mute us, please? Reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
Your Honor, on behalf of my client, I would state that he was not in need of what happened.
I'm sorry, what did you say?
He was not a leader, he was a follower. Basically, he did just enough to be charged with that offense. I believe the sentence is appropriate. We spent a lot of time bargaining back and forth, and my client has admitted responsibility.
Well, I mean, he pled no contest. So that's sort of, well, that's not sort of.
It would have to be with a situation where that offense cannot be used in a civil proceeding concerning the custody.
All right, so he's not 100% saying he's guilty. I understand the no contest, and I understand that there are issues related to it civilly, so I will leave it at that. Anything you wish to say, Mr. Espinoza Rodez? No.
Judge, just to interrupt, I did check and verify, on the approach, that's a game address, you were right, it wasn't in their count.
Okay.
So it would be that count or that part, I think it's one of the paragraphs in. So.
Thank you. So the record can be clear, the court is finding you guilty in count 1 and not guilty in count 2. The count 2 is not in Bexar County. All right. And count 1, the court is going to sentence you to 13 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with Delicia, Dilcia, Guerrero Ocampo, or Gerson, Gerson, Chicas, Chicas, Alfaro. Is there anything else from either side with regards to sentencing?
Nothing from the state, Judge.
All right, did you review the document entitled Trial Court Certification with your attorney? Did you understand it and did you sign it? Yes. Because this is a plea bargain, because I followed your plea bargain, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Yes. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes. All right, we can go to off the record. So, Mr. Rodez, I know that 13 years is a lot of time. Your attorney is telling me that you did enough to be charged with this case. I've read it. This is a pretty bad case. You should not go to somebody's house as a guest and destroy things. You understand? Yeah. So you came to the United States, for want of a better term, as a guest, and you proceeded to destroy things. You should not do that. You understand? Yes, it makes it bad for everyone else who's coming here to try to get a better life and trying to work and maybe send money home to their families. Do you understand? Yeah. All right, good luck to you. Thank you. All right, you're welcome. And everyone, we are done for today.
Except for my motion, Judge.
Oh, you need to pull those files from the back. Have them bring the files.
Oh, you like,
Yeah, they have the files in the
oh, they
back.
have them back there?
Oh, they should. If they do not, they'll explain to me why they don't have the files.
I don't have the case numbers with me, Judge.
Here you are. There you go. And
No,
we will be back tomorrow at 9 a.m. closing arguments, and then